Vincent always say Andrew Ross. Your dad's name is Andrew? Yeah, so can I introduce you as Andrew Ross? Second. He's born.
Smile, guys. We're happy to be here.
Yeah, I'm not a genius. I'm always not to be a genius.
Hello, everyone. Good afternoon. My name is Brittany Van Rieden, and I'm the current president of Moot Court. Welcome to the 72nd annual Showcase Argument. The Showcase Argument is a long-standing tradition at Notre Dame Law School and is meant to give law students an opportunity to watch talented oralists argue in front of a panel of esteemed judges. Joining us today are Judge Kelly of the 10th Circuit, Judge Kirsch of the 7th Circuit, and Judge Kness of the Northern District of Illinois. There's information on the case and the two disputed issues located in your program. If you don't have a program, throw up your hand, we can come bring you one. The appellant, Kendra Frocker, is represented by oralist Zahraa Nasser, Sydney Imes, and brief writer Meg Dalton. The appellee, the state of McGee, is represented by oralist Vincent Gangemi, Ross Dentremont, and brief writer Reid Edwards. We hope this event will be helpful for all of you as you prepare your legal writing oral arguments, and that we will all learn something by engaging with these important issues. We also hope to see you all competing in the 1L tournament later this semester. And turning now to the bailiff to introduce the case.
All rise. Oyez, oyez, oyez.
Good afternoon, you may be seated.
All persons having business before the Honorable, the Supreme Court of the State of McGee are admonished to draw near and give their attention, for the court is now sitting.
Okay, we'll call for hearing Frocker versus State of McGee. We have appearances, please, for the record.
Thank you, Your Honor. May it please the court.
Counsel, this is just for appearances, so just state your name for the record.
Yes, my name is Zahraa Nasser, and I, along with my co-counsel, Ms. Sydney Imes, represent Ms. Kendra Frocker.
Thank you. And for the appellee,
My name is Vincent Gangemi.
stand up, please.
My apologies. My name is Vincent Gangemi, and along with my co-counsel, Andrew Ross Detremont, represent the state of McGee, the respondent.
Very good. Counsel, you may begin.
Thank you, Your Honor. May it please the court. Good afternoon. My name is Zahraa Nasser, and I, along with my co-counsel, Ms. Sydney Imes, represent petitioner Ms. Kendra Frocker. I will be arguing the First Amendment issue, and my co-counsel will be arguing the Eighth Amendment issue. At this point, I would like to reserve 3 minutes for rebuttal, 1 minute from my time, and 2 minutes from my partner's time.
Counsel.
Thank you. Your Honors, petitioner requests that this court reverse the lower court's holding that Ms. Frocker's constitutional rights were not violated. We ask that you hold not only was the Eighth Amendment implicated, but Ms. Frocker was subject to cruel and unusual punishment and at the mercy of an Establishment Clause violation.
Why do you think it's cruel and unusual to take somebody in rather than have them freeze to death on the street?
Yes, Your Honor. In this case, it was cruel and unusual because Ms. Frocker had no choice but to pick whether to be arrested or ultimately be arrested.
Well,
If
they
she
did
were,
have a choice in this case, though, did they not?
Your Honor, she had no real choice. She was facing a Hobson's choice. If she chose to go to Disciple Homes, the only real homeless shelter that had beds that night, she would be subject to overtly Christian imagery that did not align with her own
Well,
beliefs.
they didn't ask her to participate. They just simply said, stand up and be polite, and essentially, and she wouldn't do that.
Your Honor, the Supreme Court in McCreary County and Allegheny County found that such passive participation still counts as coercive environment. by forcing Ms. Frocker to be in the room at all, to receive the prayer, to stand, and to remove any.
She didn't have to give the prayer. She didn't have to even listen to it. She wanted to get out of the cold. She just had to stand there.
Your Honor, respectfully, the record on page 3 says not only did she have to stand, she had to both accept the prayer, remove any applicable headwear, and remain silent. Failure to do so would have caused the shelter, Disciple Homes, to forcefully remove her from the shelter entirely, where the police would then still arrest her. Ms. Frocker here didn't have a real choice. Here, the state of McGee excessively entangles itself with religion in 3 prominent ways. First,
What do you rely on for that comment?
the Lemon test, Your Honor. The Lemon test in determining excessive entanglement looks to the character and purpose of the religious institution, as well as the resulting relationship between the institution and the government. In this case, Your Honors, the police of McGee worked hand in hand with Disciple Homes every single night.
Does the record reflect that?
Yes, Your Honor.
I thought the record merely reflected that they called in and said if they had beds available, and then the police would direct the person that way. She didn't go. She didn't want to go.
Correct, Your Honor. The record reflects that at that particular night, Ms. Frocker was sleeping in the cold, sleeting conditions and was confronted by police. They had received a call from Disciple Homes saying that they had available beds. However, Disciple Homes, in calling the state of McGee, then determined whether the statute would be given police enforcement power at all. The record reflects on page 2 that if the Disciple Homes says we do not have any beds that night, they are giving clearance to the police department of McGee not to enforce the statute at all. This is excessive entanglement with government. Disciple.
That's the choice of the police though, right? They have that in every case.
Yes, Your Honor, the police will always have discretion as to how to enforce the statute. However, in working with a predominantly religious institution, and not just religious, but Christian in nature, they are excessively entangling themselves with this religious institution.
Well, could she have said, well, I don't like the color of the wallpaper and I'm not going? And would you want to expand the doctrine that you're attempting to espouse here to include her personal predilections to the type of facility she might be put in?
Absolutely not, Your Honor. Our concern here is Ms. Frocker's religious liberty. And here, Ms. Frocker does not respond to the Christian faith. That is not her faith. And
This isn't a free exercise case though, right?
correct, Your Honor. Although we do argue that her free exercise rights are implicated, we maintain that an establishment clause issue exists here.
Well, if you maintain that her religious rights are implicated here, what burden do they put on her religious beliefs?
Your Honor, by giving Ms. Hobson a coercive decision to pick by requiring her to A, attend the shelter, go to the shelter and participate in the religious activity, or resort to being arrested, they are coercing her to religious indoctrination and participation. You see, Ms. Frocker, as the record on page 2 shows, has tried this before. It's not that this is something she heard of.
Slow down just a bit. I have a problem hearing as fast as you're speaking.
Yes, Your Honor, my apologies. Ms. Frocker, on this particular night, when the police confronted her, explained she had gone to Disciple Homes before. And when she chose not to participate, she was not only uncomfortable, but she then would have been asked to leave entirely and be caught in the same position as she would have been in if she had not gone at all. She would have been arrested.
The problem that I have with your theory here under the establishment clause approach that you're taking is I'm not seeing a very strong connection between the action of the state through the police and the argument that you make that she's being coerced to follow a particular religious viewpoint. Yes, I can readily accept that there's an overtly religious character to this shelter, but why is that the responsibility of the state? All they're trying to do is find housing. So what is the endorsement or the advancement of religion theory that you have that's really here only because the police are trying to find shelter for someone?
Yes, Your Honor. The situation in the state of McGee is actually quite unfortunate. All of these shelters are of a private nature. There are no public shelters in the state of McGee. However, in working directly with Disciple Homes, which accounts for 1/3 of all beds available on any particular night for homeless individuals, the state of McGee is entangling itself with the religious institution.
Well, let's talk about that for a second. Let's say you have a situation where there's a fire in an apartment complex in the middle of winter. And the Baptist church down the street says to the police and the fire department, we'll open our doors and anybody, who needs to come in can come in, and we'll gladly provide them shelter. Now, I'll accept that there would be a voluntary aspect to that with people who chose to go into the church for shelter, but isn't that the state involving itself with the church under your theory?
Your Honor, two responses. First, if participants here or people that are now that do not have shelter, do not have a choice and are being kind of sheltered into these churches without a real choice and forced to go or else be arrested, that would be similar to the case here.
But you could have the same lack of realistic choice with my fire analogy or hypothetical. The people would have no choice because they either freeze or they go into the Baptist church, say it's the only place to shelter. Now, I guess what I'm getting at is there's an entanglement there too of some level, but is that precluded under the First Amendment? I mean, what is the religious message that the state is promoting there by just trying to get shelter for someone?
Your Honor, there would be no entanglement issue there because those facing homelessness due to the fire are not facing a threat of arrest. Ms. Frocker here not only faces excessive fines that she is unable to pay, if she does not go to the shelter, she will be ultimately arrested, charged with a misdemeanor, and required to show up in court. Here,
That's her choice, though.
That's not what the law says. I echo that. That's not what the law says. That you've got a major causation problem here, I think, because it's not, the threat of prosecution isn't the cause of her going to the shelter, is it?
Your Honor, the threat of prosecution is if she chooses to remain in the park or not go to a shelter at all.
Well, those are two different things, though. The threat of prosecution is if she camps in the park. It's not if she goes to the shelter. There's a little bit of a disconnect that you need to connect there, right?
Yes, Your Honor. And the connection here is done by the state of McGee Police Department. In working with Disciple Homes and in waiting for this call every single night, they are entangling themselves with this institution. The state of McGee Police Department doesn't call other things that are happening that night, say a music festival or an elderly home, to see if anyone may have been sleeping in the park or lost.
Is there any evidence in the record to suggest that the police department knew of Ms. Frocker's religious objection, or the police department even knew of the religious nature of the shelter at issue?
Your Honor, the record shows that Ms. Frocker responded to the police that arrested her that night, saying she would not go to Disciple Homes because she would be required to partake in activity that offended her own beliefs.
Well, all she had to do was stand up and hold the piece of paper that they gave her. She didn't have to pray. She didn't have to disrobe or anything.
Respectfully, Your Honor, the Supreme Court in Lee v. Weitzman, in Santa Fe v. Doe, in McCreary County and Allegheny County have all found that such passive participation, even being required to stand while a prayer is read or even sit while prayer is read.
That's the AAA or the AA case.
Correct, Your Honor.
Okay, and that Alcoholics Anonymous, the entire situation is based on a higher personage. Unlike here, you have to really participate in Alcoholics Anonymous. Nobody asked her to participate in anything other than courtesy, stand up.
Yes, Your Honor. In Lee v. Weitzman and Santa Fe v. Doe, the school was held liable for an Establishment Clause violation because it required participants to simply be there while a prayer was read at a football game. The reason that the court held this was a violation of the Establishment Clause was because participants had no choice but to remain in the room. There, I argue, Your Honor, it may have been more voluntary. If you don't want to be there while a prayer is read at a football game, you are able to leave. That is indirect coercion. Here,
Why was she unable to leave?
Your Honor, if she left, she would have been arrested.
Well, no. If she left and if she camped in the park, she would have been arrested.
Your Honor, if Ms. Frocker left Disciple Homes that night, her only resort would have been to sleep in a park or in some other public location. Disciple Homes was the only remaining shelter that night that had beds available. Here, Ms. Frocker was directly coerced to stay. In Lee v. Weissman, the minority there was concerned that legal coercion has to exist in order to hold an Establishment Clause violation. Some kind of legal sanction must have been imposed. Here, Ms. Frocker, if she chose to leave, the threat wasn't just social pressure as it was in Lee v. Weitzman, where the court determined it was sufficient. Here, the threat would have been arrest, fines, and a criminal record. My last point, Your Honors, is that in requiring Disciple Homes to be a third accommodation for homeless people, the state of McGee preferences homeless people of the Christian faith over all other homeless people. There are 212 beds available in McGee State at
There are what?
any.
I'm sorry.
There are 212 beds available every night in McGee. Disciple Homes houses a third of these beds. That gives Christian homeless people the option of a third more beds than any other homeless person in the state of McGee. In doing so, the state of McGee violates the free exercise clause of Ms. Frocker as well as an establishment clause.
But hold on one second. It doesn't violate the free exercise clause unless it puts a burden on her religious beliefs, right?
Yes, Your Honor.
So what is the burden placed on her religious beliefs?
In requiring Ms. Frocker to partake in a religious exercise, in this case, standing for the prayer, being subject to the imagery, she is being required to partake in a religious exercise that is not her own. For the foregoing reasons, Your Honor, we respectfully conclude and ask that you vote for petitioner in saying that her constitutional rights weren't violated. Thank you.
Thank you. Counsel.
May it please the court. My name is Sydney Imes, and as my co-counsel, Ms. Nasser stated, I will be arguing the Eighth Amendment issue. We respectfully request that you find that Ms. Frocker's Eighth Amendment rights were violated in this case for 3 reasons. First, the McGee statute criminalizes necessary human behavior. Second, the McGee statute fails to adequately advance the goals of criminal punishment. And third, the McGee statute grossly offends our understanding of human dignity and decency. At issue here is the criminalization of the homeless merely for sleeping, in clear violation of the Eighth Amendment.
Well, this is not a pure status offense.
Your Honor,
When there are beds available, it takes it right out of that series of cases.
2 points, Your Honor, on that. First, there were no beds practically available to Ms. Frocker on this night in question, seeing as how her only option conflicted with her religious beliefs. Therefore, she had to spend the night in the park. Second, Your Honor, I would point you towards Martin
Doesn't that
versus.
depend on how valid her complaint was or her concern?
Your Honor, no, because the statute on its face criminalizes necessary human behavior by including sleeping as indication of camping in the statute. Therefore, on its face, it's criminalizing necessary human behavior. Furthermore, as it pertains to that status and conduct distinction, we can look to Martin versus City of Boise, in which they held that the two were inseparable from one another, given the fact that homeless people have to rest somewhere. Human
Is
beings.
the Ninth Circuit case of Martin your only support for that proposition? Are there any other courts that have held that?
Yes, Your Honor, multiple other courts have. We can look to the 11th Circuit, for example, in Joel versus City of Orlando. Another Ninth Circuit case as well, Jones versus City of Los Angeles is relevant here. We can look to the 3rd Circuit, Young versus Quinlan, even the 4th Circuit, Manning versus Caldwell. There's numerous support across all the different courts for this proposition.
Well, in those cases, isn't the fact that that was a pure status issue? Simply because you were homeless, you would be detained. Here, there's an option, and you only become homeless when you exercise that option not to go because you don't want to.
Respectfully, Your Honor, there is no option here for Ms. Frocker. And furthermore, if all the beds in McGee had been full on that night, then she would have been forced to sleep in the public park regardless.
If that had been the case, the city didn't enforce that ordinance.
On that night in question and on other nights, they didn't have to enforce the ordinance, but they could. And that alone is enough. And
Well,
again,
wait a minute. You're not challenging the constitutionality of the statute on its face, right? You're just challenging the constitutionality of the statute as applied.
we are arguing both, Your Honor, actually. The statute on its face criminalizes necessary human behavior by including sleeping, but
No,
also,
it just criminalizes camping.
Your Honor, in the statute itself, though, it includes sleeping as.
But the statute, you would agree, applies to protesters and Boy Scouts and Girl Scouts and everybody, right?
Your Honor, it does, but it's not being enforced that way.
Well, then it's as applied challenge, right?
It could be both, Your Honor, in this case. It's specifically as it pertains to Ms. Frocker, we can again look to Martin versus City of Boise. The statute there was nearly identical.
The problem with Martin, though, where you have a tough time convincing me to apply Martin in this case, the problem with Martin, as Judge Kelly mentioned, is Martin, it goes beyond criminalizing status, like the mentally ill or someone with a venereal disease or someone who is homeless. It allows for the criminalization of conduct. And that's what the state is criminalizing here. They're criminalizing conduct, camping in the park, not the status of being homeless. Because the conduct would apply to the Boy Scouts and to the Girl Scouts and protesters and everybody else. And the police have the right to enforce the statute. They have discretion to enforce the statute, right?
Yes, Your Honor, they do. However, I would point you towards Joel versus City of Orlando, in which case they held that it was conduct only when there were when there were beds available in Orlando. When there were no beds available in Orlando, then the distinguishment between status and conduct disappears. It becomes inseparable.
You keep talking about this difference between status and conduct, and you rely, I understand why, but you rely heavily on the necessity of sleeping, correct?
Correct.
Well, there are other human aspects of conduct that are necessary. For example, going to the bathroom. Would the state here be permitted to preclude people from relieving themselves in the public park or public spaces?
Yes, Your Honor, of course. And that actually brings me to my second point as it pertains to the state's approach to this. We are by no means suggesting that the state cannot criminalize actions like going to the bathroom in the park, like panhandling, things of that nature. Rather, we must draw the line at criminalizing someone for necessary human behavior such as sleeping. And I would point you
but if somebody has to go to the bathroom, they have to go to the bathroom. And if there's no public restroom available and they're in public and they don't have a house, they don't have their own bathroom, where are they supposed to go to the bathroom?
Your Honor, 2 points on that. First, that's more of a voluntary behavior. There's always public restrooms available. There's
Well,
always a McDonald's you
assume
can
with
go
me
to.
for a second that there aren't public restrooms available. I'm trying to get to the point of what's the limit to your argument. Assume there aren't public restrooms. Let's assume you can't go to Starbucks and use the bathroom there as a homeless person, but you have to go to the bathroom. And the only place to do it is in the park. Would the state be allowed to criminalize that conduct?
Yes, Your Honor. And we are suggesting a very narrow holding here, to be clear.
Only for sleep.
Only for sleeping, sitting, lying outside on public property when there is nowhere else to go.
But how do we draw that line? Once we issue an opinion here, every municipality in the circuit will look to this opinion, which will state the law. This is what cities can do and this is what they can't do. How do we draw the line? I think which was Judge Kness is asking how do we distinguish between sleeping and using the bathroom or other natural events that occur to humans?
Yes, Your Honor. 2 points on that. First, you could distinguish between sleeping and other types of behavior. Make it very clear that it's just sleeping.
But on what basis? So we can't just say what we want the law to be. We have to say what the law is and why under the Constitution. And what are we going to base that on?
Your Honor, you could base that on Joel versus City of Orlando, for example.
Well, yeah, but that's not binding authority on us.
Correct. We could also look to Robinson versus California in that case. Now, they made it very clear in that case that there were limits to what the state can and can't do. The state can criminalize certain sorts of behavior, such as being
just it's dealing drugs. However, they couldn't criminalize someone for being an addict. The same sort of thing can be applied here. Can't criminalize someone for being homeless. This grossly offends our standards of
But
human
that's not,
dignity.
that gets back to status versus conduct, because the statute doesn't criminalize homelessness. Just like it doesn't, it criminalizes the Boy Scouts and the Girl Scouts equally to homeless folks. It's not criminalizing status, it's criminalizing conduct. And doesn't that create a problem for you?
No, Your Honor, because we can look to precedent that isn't binding on us, but is still persuasive in Martin versus City
Well,
of
it's not
Boise.
persuasive to me.
Understandable, Your Honor. We can still look to other sorts of precedent, though, such as Powell, in which the Supreme Court noted that distinguishment. Numerous circuits have held that the two are inseparable when we're dealing with these sorts of issues. Status and conduct here are intertwined completely. We can't necessarily separate out one from the other. And regardless, this grossly offends our standards of human dignity. The Supreme Court in Trott v. Dulles noted that when analyzing these sorts of issues, we need to look to our evolving standards of decency. Now, in cases like these,
Does the homeless person have any obligation to avail themselves of what is available?
I don't understand the question, Your Honor. Could you rephrase that?
Just as does the homeless person, can that homeless person say, I just don't want to go there. I don't like the color of the walls.
No, Your Honor. This is strictly about her religion. If it was just about the color of the walls, we would not be here today. We suggest a very narrow holding here. Furthermore, it's
Well, but the fact is that the award's a bed available.
respectfully, Your Honor, not to Ms. Frocker. It would have violated her constitutional rights. And the fact that
Well,
she,
that's the other question.
yes, Your Honor, but I think it speaks volumes to the fact that on page 3 of the record, it indicates that as a woman, she chose to sleep in a public park in near freezing conditions. That's how much her religious convictions meant to her in this case. That proves that she really didn't have a choice here. She went to the park because she had to. She could have
Well,
been.
I understand the link between the First Amendment and Eighth Amendment components here as part of your argument. I do know that they're largely inseparable, but just assume with me for a moment that the basis of your client's objection to going to the other shelters because she just didn't like it, which goes to Judge Kelly's point. Let's say she hated it. Maybe there was somebody there she didn't like. Maybe a former romantic partner was there and she just couldn't stand being in the same room. She just did not want to go there. Under those circumstances, would the state be permitted to give her the choice of you either go there or you're going to get arrested and be criminally prosecuted?
Your Honor, since we're relying on Joel versus City of Orlando, then yes, in that case, she could be criminalized for that behavior. It's really about the number of beds available. And we're not suggesting that the state has to provide these beds at all. We're not suggesting any particular avenue for the state to take.
But that's in some tension with your argument about human dignity and why there's something so inherently offensive about requiring a homeless person to make a choice or face prosecution. Doesn't that undercut the fervor of your Eighth Amendment argument to say that there's some situations in which she could appropriately be punished?
No, Your Honor, it doesn't, because in those situations, she would have a bed to go to. Therefore, we wouldn't be criminalizing necessary human behavior in those cases. What grossly offends our standards of human dignity is the fact that she didn't have anywhere to go. She was homeless. And because she had that situation that she was dealing with, and because that forced her to sleep in the park, that's what grossly offends our standards of human dignity and decency. And the Supreme Court in numerous cases, such as Ingraham, often looks to the national consensus first as a factor in determining what grossly offends our standards of human dignity and decency. And numerous studies published recently, one in the American Journal of Community Psychology, have noted that we as an American society have adopted far more liberal attitudes towards homeless people. In fact, Americans in the last decade have become far more likely to allow homeless people to both sleep outside and even panhandle outside. Now, we're not suggesting that much. We're simply saying that as it stands right now, this grossly offends our standards of human dignity. The same sort of thing was noted in Pottinger versus City of Miami, in Joel versus City of Orlando, Martin versus City of Boise. All of these cases noted that criminalizing homeless people for unavoidable behavior like this grossly offends our
But in all
society's
those
standards.
cases, they had no other alternative. And if your argument or your partner's argument on whether it's making somebody stand up or take their hat off does not constitute a First Amendment violation, where do you go with your argument?
Your Honor, while the two are entangled here, you could,
I'm sorry.
Your Honor, I see my time has expired.
You
May I
may answer
answer?
the question.
Yes, Your Honor. The two are entangled here. However, the fact that it criminalizes sleeping on its face of the statute should be noted as an indication that it's targeting homeless people and criminalizing necessary
Right.
behavior.
Thank you.
For these reasons, we respectfully request you find her Eighth Amendment rights were violated. Thank you.
Counsel, you may proceed.
May it please the court. My name is Vincent Gangemi, and along with my co-counsel, Andrew Ross Detremont, represent the respondent in this case, the state of McGee. The issue I will be addressing before this court today is whether the trial court erred in finding that Ms. Frocker's rights under the First Amendment were not violated through the state of McGee's enforcement of the camping statute. We respectfully request this court to affirm the finding of the trial court because the answer is no for two fundamental reasons. Firstly, because petitioner has failed to demonstrate that the actions of the state of McGee have violated the Establishment Clause under Lemon or any subsequent test the Supreme Court has put forward. And secondly, because the state of McGee has relied on history and tradition in enacting the statute. To expound, the Supreme Court in Lemon.
Can you go right to the second issue and explain how has the state relied upon history and tradition in enacting this statute?
Of course, Your Honor. The Supreme Court has repeatedly held that if a religious practice is based upon history and tradition, the practice does not violate the Establishment Clause. This rule supersedes the test the Supreme Court has put forth in Lemon and Lee. Longstanding practices with sufficient evidence of history and tradition, here relying on religiously affiliated private organizations to deliver public services, or more generally, broad ceremonial prayers at government-related functions, can continue without violating the Establishment Clause. This history.
That's a bit of a strong. Sorry, go ahead, Judge.
I mean, it sounds like that you would agree that the government is coercing Ms. Frocker's participation in religious practices through the enforcement of this rule. If that's your argument, I'm confused a little bit. I thought you were arguing that the government was not coercing her participation in this rule, but if you're suggesting that, are you suggesting it's okay if the government coerces her participation in this rule of the prayer based on history and tradition?
Your Honor, the argument that the respondent is putting forward is essentially twofold. First, we're arguing that under the coercive test, or for that matter, any Lemon test that the Supreme Court has subsequently put forward, the state of McGee's actions have not violated the Establishment Clause. So we would contend that the actions of the state were fundamentally not coercive. However, even if this court were to find that the actions of the state were coercive, in the alternative, the Supreme Court has made clear that a longstanding practice that has sufficient history and tradition can still survive under the Establishment Clause.
How were the actions not coercive?
Your Honor, to explain the Supreme Court's coercive test under Lee, essentially the Supreme Court held that the Establishment Clause, at a minimum, guarantees that the Constitution may not coerce anyone to support or participate in a religious exercise. However, if we were to unpack the facts of Lee, we find that the case before the court today is quite distinguishable. Firstly, Lee ultimately held that a principle directing the content of the prayer had some fundamental issues with government becoming entangled with religion. Secondly, the Supreme Court found that there was something special about the student-teacher relationship. And it's for that reason that over the past 3 decades, the Supreme Court has repeatedly denied the opportunity to expand Lee outside of the school context. To expound on the particular cases that our friends across the aisle have relied upon, the Ninth Circuit in Inouye and the Seventh Circuit in Kirsch have held that the religious focus of Narcotics Anonymous and Alcoholics Anonymous programs for prisoners and parolees have conditions of confinement that violate the Establishment Clause, specifically because the Establishment Clause exists to protect people from a government force of, excuse me, Your Honors. The Establishment Clause exists to prevent the government from stepping in and having the object of a rule be coercion itself.
Would she be coerced if she voluntarily went to the shelter because there were no beds anywhere else except for this particular shelter, and she wanted to avoid arrest? If she went to the shelter and she refused to stand during the prayer, or she refused to remove her hat, and she then left the shelter and went back to the park and was subsequently arrested, would she have been coerced?
Your Honor, under the Supreme Court precedent, particularly in Town of Greece, the answer is no. In Town of Greece, the Supreme Court clarified many of the holdings in Inouye and Kirsch. Specifically, it said that the bounds of the Establishment Clause presume that an adult citizen, firm in their own beliefs, can tolerate and perhaps appreciate a ceremonial prayer delivered by a person of a different faith. The record at 2 makes clear that the
What's ceremonial about this prayer, though?
Your Honor,
I guess what I'm asking again, where do we draw the line here? What if there was, I think from the facts, there were Christian scenes on the wall? What if there was a crucifix? What if she was asked to kneel during the prayer? You can think of other examples. What if she was asked to bow her head in the direction of the crucifix? Would that change your argument at all?
Your Honor, respectfully, it would not. In Town of Greece, the Supreme Court has made clear that offense does not equate to coercion. A court may construe a religious prayer service as coercive only if over time it has shown that there's invocations of denigrating non-believers and minorities, and it threatens some sort of.
Well, wouldn't that happen though with certain religions if you force them to bow or kneel in front of a crucifix?
Respectfully, Your Honor, in this case, it would not. That specifically is because Disciple Homes, the record at 2 makes clear, is open to people of all faiths or no faiths at all.
But that's not the question, though. The question that Judge Kirsch is asking is, at some point, let's say we have a Muslim person who is required to go to the shelter and then required to bow in the direction of the crucifix under the hypothetical. I recognize those aren't the facts here, but under the hypothetical, that would, I think you would have to agree with me, that would be a bridge too far for the person, and they would leave, correct?
Your Honors, I wish to
Well,
engage.
yes or no, correct? Yeah, am I wrong or am I right?
No, Your Honor.
I'm wrong.
Yes.
Okay, tell me why.
Firstly, before engaging with the hypothetical, I wish to make clear that the Supreme Court in Town of Greece stated that the court will only consider tangible evidence of adverse consequences to determine if.
Okay, the adverse consequence here is that you go back to the park and you get arrested and prosecuted.
Your Honors, the adverse consequences from Ms. Frocker's point of view under the Establishment Clause was that she would have to stand in respect for the prayer that was generally
Right, so back to the
ceremonial.
hypothetical. And it's a hypothetical, all right? It's not the case we have, but we're trying to find out what the line is here. So we have an individual who is Muslim or another faith where the idea of bowing toward a crucifix is going to be highly offensive. What What is your explanation for why that's not coercive?
Your Honor, because there is no specific profession of a belief. Again, to reiterate the Supreme Court's precedent on Lee, it has never expanded it outside the school setting. So looking to what the circuit courts have generally expanded Lee to cover, it's generally some sort of forced expression of a specific belief. Going back to the Narcotics Anonymous and Alcoholics Anonymous, both the court in Inouye and Kerr had a particular trouble with the fact that of the 12-step program, all steps being mandatory to pass the program, 4 steps in particular gave reverence to a higher power and had individuals accept that higher power into their lives.
So requiring someone to turn toward a religious symbol and bow toward it is not requiring them to acknowledge it and show subservience or respect to it. Is that your argument?
Your Honor, it is requiring showing respect. However, the issue that the court should consider is whether it's forcing an individual to accept those beliefs.
Where would you draw the line? I assume you would agree that if an individual was forced to lead the prayer, that would draw the line, right?
Absolutely, that would draw the line.
What about if they were forced to recite the prayer, to just read the prayer from the paper along with everybody else? Would that cross the line?
Yes, Your Honor, that is a specific belief that the defendant would have to say and presumably accept as a condition for them to stay at the home.
So distinguish between reciting the prayer and genuflecting in front of a crucifix.
Well, Your Honors, to be clear, if they were to genuflect in front of the crucifix, that would be presumably an acceptance of the belief held. To Judge Kness's example, specifically if some kneeling was forced, that would not particularly indicate that the individual personally accepted the views that were espoused at the shelter. It would be something either through actual speech or symbolic speech, where it was clear that the government indirectly was forcing the individual to accept the religious message as part of their own beliefs.
How do you expect municipalities, trial level courts, anybody who would have to apply the standard to do so workably with what you're proposing? Would we have to come up with a chart saying that if you don't bend more than 45 degrees, it's okay? I'm really struggling. I need your help with this on how that is a standard that can reasonably be applied in practice.
Respectfully, Your Honor, the respondent is of the opinion that if the court were to rule against us today, the standard put forth would be even more complicated. Justice Rehnquist's dissent in Aguilar warns of a catch-22, whereby organizations must be supervised to ensure no entanglement with revision, but supervision itself is held to have caused that entanglement. For this reason, 12 years later, the Supreme Court in Agostani subsequently overruled the decision. So if this court today were to hold that the actions of the state of McGee were unconstitutional, then essentially it would be mandating that the legislature step in and put in some guardrails for what is and is not okay at disciple homes. However, those guardrails violate government entanglement with religion to begin with. To expound on the history and tradition point that I mentioned earlier, McGee has not violated the Establishment Clause in enforcing the camping statute against Frocker because the churches and other faith-based organizations within the state and throughout the United States more generally have been at the forefront of sheltering the homeless for over a century. In 2017, a study from Baylor found that across major cities, emergency shelter beds at the low end, 33% were provided by faith-based organizations, and at the high end, as much as 90% were provided by such organizations. In fact, the Salvation Army, one of the world's largest and oldest providers of social aid, was founded in 1865. A number of district courts have held that absence a program which, as I mentioned earlier, professes specific beliefs. There is
I don't think the issue here is the character of, or the mere fact that the shelter is a faith-based provider. I don't think that's the issue. The issue is what they're requiring the people who go there to stay to do. So of that percentage of, between 10 and 90% of homeless shelters are provided by faith-based organizations. Do you have any facts in the record, or can you recite anything from that study that shows how many of those required the same level of steps as the shelter here did?
Respectfully, Your Honor, the respondent disagrees with that characterization.
What characterization? I'm trying to understand do you have any facts can you tell me anything about that study that says anything about the level of activity or, religious symbols on the wall, all the things that are in the record about this shelter apply to those other shelters referenced in the study?
The characterization that the respondent disagrees with is that there's anything more than a minimal question of respect that is required by disciple homes. Essentially, this court should understand that most religious-based organizations can presume that everyone they work with have some basic respect for the practices that are at the core of the organization itself. This court should
What is your basis for saying that?
Excuse me, Your Honor?
What is your basis for saying that, for that assumption? I'm not sure that's necessarily an assumption I agree with. That's an assumption that I agree with. I think are you saying that there are no faith-based providers that are willing to provide services to people no matter what they think, or whether they respect religion or not? I'm trying to understand the contours of what you just said.
Your Honors, it would be clear that most faith-based organizations provide these services regardless of the faith of the individuals. Your Honors, I see my time has expired. May
Complete the answer.
Thank you. Most religious-based organizations will be open to people of all faiths. However, disciple homes, the record makes clear, is open to people of all faiths. The line this court should draw is if these organizations require the individual either verbally or non-verbally to espouse specific religious beliefs. Your Honors, it is for the foregoing reasons that we respectfully request that this court find that the trial court did not err in holding that Ms. Frocker's rights were not violated by the Establishment
Thank you.
Clause. We pray for your affirmation.
Your Honors, may I proceed?
You may proceed.
Your Honors, and may it please the court. My name is Ross Dentremont, and as my co-counsel stated, I will now represent the respondent, the state of McGee, on the 8th Amendment issue. Your Honors, the petitioner incorrectly asserts that the McGee statute prohibiting camping violates the 8th Amendment. This assertion is incorrect for two main reasons. First, the statute on its face criminalizes conduct, not status. Then derivative of the first to the second point, Your Honors, under the jurisprudence of the United States Supreme Court, criminalizing conduct comports with the 8th Amendment, so long it does not comport or so long as it does not criminalize status. For those reasons, Your Honors, we ask that this court affirm the lower court's conviction of the petitioner. Turning to my first point, Your Honor, that when we look at the face of the statute, it criminalizes conduct rather than status.
Mr. Dentremont, I don't think you have a problem convincing us of that, okay? The facial, the constitutionality, facial challenge to the statute. But as applied, is there any circumstance here where the statute could violate the 8th Amendment? And I want to go back to the question that I asked earlier. If Ms. Frocker was told to go to the shelter and she did, and then she was asked to engage in religious practices with which she would not agree, whatever they were, and she left the shelter and upon leaving the shelter was arrested because she had nowhere else to go, would the statute as applied violate the 8th Amendment?
Respectfully, Your Honors, I would like to respond to that in two ways. The first is that respondent does not contend that you must fine for the respondent on the First Amendment issue in order for the respondent to succeed overall and for you all to affirm the lower court's holding. Indeed, now to answer the premise of that question, Your Honor, it would not violate the Eighth Amendment. Indeed, as Your Honor has already said, to survive a facial challenge would be a high burden here that under the United States v. Salerno would not be able to hold against this statute. So we must turn to an as-applied challenge. In order to survive then that as-applied challenge, or to state it a different way, in order for petitioner to have this statute struck down as applied, she would have to show that her constitutional rights have been violated. Petitioner artfully suggests that the issue here is sleeping and that the McGee statute violates or criminalizes sleeping. Ultimately, Your Honors, that is not the premise on which the respondent.
So I want to get back to my hypothetical question here. So if she was to go to the shelter and leave the shelter for any reason at all, whether I don't want to entangle this with the First Amendment, I want you to just focus on the Eighth Amendment. If she was going to leave the shelter for any reason at all, shelters, by the way, are dangerous places. Just so you know, you may not know that, but they're dangerous places. And she may feel unsafe in the shelter and decide to leave the shelter at 11 o'clock or midnight, go back into the park. As long as she stays awake, I assume she's not violating the statute, right? Or is she?
Your Honor, she could still be violating the statute in that hypothetical.
I agree with that. So wouldn't they, if they arrest her, wouldn't they be arresting her at that point because of her status of being homeless?
Respectfully, Your Honor, no, they would not be doing it for the fact that she was homeless. And to offer our own hypothetical from the respondent, imagine that a non-homeless person was trying to camp in the park at 1 o'clock in the morning.
But that's not the question though, because remember, we're talking about an as-applied challenge to this particular defendant.
Your Honor, in that case, still as applied, it would not matter because to go back to the as-applied challenge, petitioner must show that some of her constitution or one of her constitutional rights has been violated. And ultimately, the petitioner has stated that she believes that the right that has been violated is her right to sleep. Respectfully, Your Honors, it is the respondent's position that what petitioner is truly saying is that any right that would have been violated would be her right to shelter. And ultimately, Your Honors, the United States Supreme Court has already issued its decision on this back in 1972 in Lindsay versus Normant. In Lindsay, the court said that no individual has a federal constitutional right to shelter or adequate shelter, which would cover your hypothetical.
No. That's not what she's arguing though. She's arguing if she went and laid on a park bench or laid on the grass and went to sleep, she could be arrested for violating the statute, right?
Correct, Your Honor.
Nothing to do with shelter. Forget the plastic drop cloths and those sorts of things. There's nothing to do with shelter. She could be arrested. And why, as applied to her, would that not be criminalizing her status as a homeless person?
Because, Your Honor, the petitioner has not stated why she would have a right to be in the park. The only thing petitioner has said is that based on changing or evolving beliefs of human decency, she should have the right to the park. And I think here, Your Honor, it would be respondent's position that there's almost an emotional charge to this. And the respondent feels the sympathy of the petitioner. It is a homeless person in a public park. But Your Honor, there might be another scenario where it's not a homeless person. It could be someone visiting and all of the hotels are full. There is no room in the inn. Just because there is someone in the park at that time, it should not matter whether or not they are homeless or not. What matters, Your Honor, is that they have violated the statute, and petitioner in no way asserts why she should have the right to remain in the park. And indeed, Your Honor, this is a slippery slope argument. Here, the facts are somewhat amenable because it's a public park.
Before we go sliding down the slope here, let me ask you about the statute, because we keep talking about parks, and that's the most likely place where people would sleep. But there's nothing in the statute I see that limits the ban on camping to parks. It's jurisdiction wide, correct?
Correct.
So if you assume with me that that Ms. Frocker is homeless, and if you assume that there are no available shelters at all, and if you assume that the state is going to prosecute, she's homeless, she's got no place to sleep anywhere in the town, she has to sleep, correct? I mean,
Yes, Your Honor.
biologically, she has to sleep. So
Yes, Your
what
Honor.
is she supposed to do? I'm not looking for a legal doctrine. I just want your explanation. What's she supposed to do? There's no place for her to sleep. She's homeless, and yet she has to sleep.
Respectfully, Your Honors, that is an issue for the legislature, not an issue here today. To go back
Well,
to,
I'd like an answer to my question.
respectfully, Your Honors, I do not have a solution. Fortunately, I'm not in a
I
legislature
think
to make,
the Eighth Amendment provides a solution, doesn't it?
not according to Lindsay v. Normett, Your Honor. And Lindsay v. Normett, the United States Supreme Court has already said that there is no right to shelter, no federal constitutional right to shelter.
What was the, refresh my memory, what was the context of that case?
Your Honor, I believe the context and the facts of that case dealt with a petitioner who believed that, actually believed it was an unsafe shelter. There, she did not feel comfortable inside the shelter, and so the petitioner left and was then later arrested. And what the court said was you had no right to have to be there. Indeed, imagine a town or city in which there is no homeless shelter. The Supreme Court made clear that just because there is no shelter, it doesn't mean that someone has then a right to have that shelter there. And then if we turn now to directly respond to some of
Did the
petition.
Supreme Court put that in terms of the Eighth Amendment, in terms of prosecution? Or was it in terms of some other legal right? I'm trying to understand and recall the facts of that case.
Yeah, I believe it was a different I believe it was almost a 14th Amendment issue, was not an 8th Amendment issue. But what they ultimately held was that no person had the right, federal constitutional right to shelter in that case.
Okay, they don't have a federal constitutional right to having the state provide shelter. Is that what you're saying?
That's correct, yes, Your Honor.
But then we're talking about a prosecution here. So I'm trying to I have no agenda. I'm trying to understand the facts of the case. Was the idea then, or is your argument that there's no difference between those cases, or is there some daylight there because we're talking about a prosecution and an Eighth Amendment claim here?
Your Honor, there is no daylight there. It's all night in this case. And so the issue here, Your Honor, is whether or not someone has a federal right, federal constitutional right. I understand Your Honor's point that it might be different if it's someone who believes they have the right to shelter versus whether or not they're now being prosecuted, and therefore they should not have to be prosecuted if no adequate shelter is provided. But Your Honors, that would be almost a distinction without a difference, because ultimately then no state would be allowed to have a law that would then criminalize this issue, because any person would be able to go and camp in a public vicinity without being prosecuted. And for those reasons, Your Honor, there would be no daylight there. Now, to turn back to the petitioner's contention of this evolving decency that needs to change. First, Your Honor, we look to where petitioner relied on in that case, which is largely Atkins and Ingraham. And in Atkins, Your Honors, what the court said is that it rested part of its decision of this evolving national standard of decency on whether or not there could be any justification for punishment in that case. And what the court said in regards to someone with a mental incapacity and whether or not they should face the death penalty is that there would be no justification served, no punishment justification served in that scenario. However, we then turn to Powell, which petitioner also relies on. And in the plurality opinion of Powell, the court made clear that in some scenarios, even though some conduct is just ultimately the petitioner or the person will have to do that conduct, there can still be a deterrence factor that rests in the statute that prohibits certain conduct. So just as in Powell, when it dealt with someone who was an alcoholic and could not control his conduct, the court still said there could be a deterrence, even though the petitioner there felt as though he had no choice but to act in a certain way.
Mr. Dentremont, I know time is shorter. Can you distinguish Martin?
The Ninth Circuit case?
Yes.
Respectfully, Your Honor, respondent does not see how Martin could be distinguished from this particular instance. However, we actually point to the 11th Circuit, which petitioner also seems to rely on. In the 11th Circuit has now held that homelessness in and of itself is not a protected class. And actually in a recent case, I believe also out of the state of Florida, it held that simply because someone has nowhere else to go does not mean in that instance that because they were arrested, perhaps for sleeping in a public institution or a public park, that person's constitutional rights have been violated. So as far as Martin being distinguished, we simply say that Martin is not binding here, but rather the Supreme Court precedent, including what it has said in Robinson v. California, where it had the conduct and status distinction, ultimately then in Powell, all the way to the 1972 case in Lindsay v. Normett, that all of the binding precedent here, Your Honor, is on our side. And indeed, petitioner brings up the 11th Circuit case. However, that was only held in a district court, which later could very likely be overturned after the court's holding that homelessness is not a protected class. Now, Your Honors, as we have made all of these constitutional arguments, we also turn to the mere fact that petitioner has not stated anything about whether or not this only applies to parks or anywhere else. Your Honor, the statute is capacious, as Judge Kirsch said, that it prohibits camping in any public vicinity, not just parks. That was the decision of the state legislature with which they are opposed with that responsibility. Certainly, it cannot be petitioner's contention that so long as there is a public vicinity, someone has a right to their sleep there. There are numerous places that it would make no sense for the petitioner or anyone else to take up camp. For those reasons, Your Honor, the McGee statute, which prohibits the conduct of camping, is certainly well within the constitutional parameters of McGee to pass and to then enforce.
Could the state prohibit eating in the park?
Yes, Your Honor, they could. I see no reason why that would ever necessarily violate a constitutional principle, because then again.
But it could as applied, right?
Your Honor, in order for an as-applied challenge to suffice there, someone would need to show that their constitutional rights have been violated. And I do not see which one of the constitutional rights would necessarily have been violated if McGee decides that you cannot camp or you cannot eat in the park. Just as I'm sure there are many instances, this is hypothetical, but perhaps there's a rule against eating in a federal courthouse or a public courthouse. Certainly it would not be petitioner's contention that that would not be something that could be enforced, or that someone has a constitutional right to necessarily eat in the courthouse, or at least in the middle of court. For all of these reasons, Your Honors, it clearly shows that the 8th Amendment has not been implicated, as the lower court has said, and the 8th Amendment does not bar the enforcement of the statutes. And for those reasons, Your Honor, we ask this court to affirm the lower court's conviction of the petitioner. Thank you.
Thank you.
Your Honor, may I have a few moments to confer with my co-counsel?
I'm sorry?
May I have a few moments to confer with my co-counsel before
Sure.
rebuttal? Thank you.
Let's hold it down, please. All right, counsel. Ms. Imes, are you ready?
Yes, Your Honor. May I proceed?
You may proceed.
May it please the court. Your honors, I have 3 points to address on rebuttal. First, as it pertains to the First Amendment issue, respondent relies on a case in which they were free to leave, Town of Greece. That is the key distinguishment here. Ms. Frocker practically did not have a choice there. Furthermore, the Supreme Court has held time and time again in these sorts of cases that religious imagery alone violates the Establishment Clause.
Well, I
Furthermore,
find that hard to believe if you have a soup kitchen in a church, that it's going to be a violation of any constitutional provision if there are religious pictures around because it's a church. You're going to wipe out all soup kitchens?
no, Your Honor, respectfully, the distinguishment there would be that that is a church. This is a shelter.
Well,
Furthermore,
it's a church shelter. It's used for something else if it's not being used as a shelter. Now, you're saying that if you do charitable work, you've got to strip it of all artifacts of religion?
no, Your Honor, we are not suggesting that. We are simply saying that the two are entangled here since the government is working with the shelter by calling the police every night. And that's why they can't have this sort of imagery per Supreme Court precedent. And also, when we're turning to the Eighth Amendment issue, respondent wants to say that we're suggesting a slippery slope, but it's pretty clear that they actually are. If we can allow someone to be criminalized for sleeping in a public park, that means if any of us went to McGee today and fell asleep, we could be put in jail. Furthermore, that would lead to more implications such as criminalizing people for eating in the park. Hey, even just being in the park could be criminalized then. That is a slippery slope. My final point is that we completely agree that there is no right to shelter. We are by no means advocating for the notion that the government has to provide shelter. Of course not. We are not even suggesting that the government take any particular approach. We are merely saying exactly what they said in Robinson, that you can't prosecute them for this. You cannot brand them with the stigma of being a criminal, as Justice Douglas wrote in his concurring opinion in Robinson. That is the distinguishment. It is for the foregoing reasons that we respectfully request that you find for the petitioner, Ms. Kendra Frocker. Thank you.
Thank you. Court will be in recess.
Your Honors, we'd like to ask you to give some feedback on oral argument, either the performance of our oralists here or general advice about oral argument, because our 1-hour students have their oral arguments next week. So if you would take a few moments, if you wouldn't mind.
Well, could we go in and deliberate on this and then come back
And you
and?
don't have to reach a decision.
No, I understand that, but I think we need to talk about it for a minute anyway.
All rise.